Abalamuzi ba kkooti ensukkulumu olwaleero batudde ne bawa ensala yaabwe mu musango ssaabawolereza wa gavumenti mwawakanyiza ensala ya kkooti etapula ssemateeka eyayimiriza kkooti y'amagye okuvunaana abantu ba bulijjo mu kkooti ey'ekinnamagye. Kidiridde yaliko omubaka wa Nakawa Mike Baziguruka okuwaabirwa ssaabawolereza wa gavumenti mu kkooti etapula ssemateeka ng'awakanya eky'okuwozesa mu kkooti y'ekinnamagye nga tabeerangako munnamagye. Era wano kkooti etapula ssemateeka yavaayo netegeeza nti kimenya amateeka okukakana nga ssaabawolereza wa gavumenti ajulidde mu kkooti ensukkulumu ng'awakanya ensala eyo. Kati olwaleero abalamuzi nga bakulembeddwamu ssaabalamuzi Alfonso Owiny-Dollo, Elizabeth Musoke, Catherine Bamugemereirwe, Monica Mujenyi Kossa Nabala bategeezezza nti kimenya amateeka okuwozesa abantu ba bulijjo mu kkooti y'ekinnamagye okukakana nga kino kiyimiriziddwa.
I said all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. All pending trials or partly heard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. The cross appeal is hereby allowed. The respondent is entitled to the cost of this appeal and in the Constitutional Court.
Bano bagamba nti kkooti y'ekinnamagye teyeetengeredde mu nkola yaayo ey'emirimu so nga tenengeri gy'ekolamu emirimu gyayo ekundana ne ssemateeka.
In their current form, courts martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda.
Void for vagueness doctrine essentially requires that a penal statute define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness.
Omulamuzi Catherine Bamugemereirwe mu nsala ye agambye nti kkooti y'ekinnamagye okuwozesa abantu ba bulijjo ekikola mu bumenyi bw'amateeka.
General Court Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offences under the Penal Code or other enactments. I would forthwith suspend all operations of courts martial, save for the hearing of disciplinary matters pertaining to serving office.
Ye omulamuzi Person Night Tuhayise agamba nti okuvunaana abantu ba bulijjo kulina kukolebwa ssaabawabi w'emisango gya gavumenti muyite DPP so si kkooti martial eyassibwawo okukwasisa empisa mu bajaasi b'eggwanga.
The General Court Martial was therefore established as a specialized court of the military forces.
General rule ought to be that military service offences are only triable in military courts and civil offences are only triable in civil courts, save for 2 exceptions. To constitute sufficient reason to declare the respondent's arraignment before the General Court Martial a violation of the right to a fair trial.
Grace Namubiro, Kuradrim TV, Amakongonte.